Good afternoon. It's not every day that we welcome a legend to campus. And today is especially wonderful in that the legend is one of our own, Fred Gray, class of '54, here to have a conversation with Dean Enton about his book, Bus Ride to Justice, A Conversation with Fred Gray. Mr. Gray is one of our most distinguished graduates, a legendary civil rights lawyer whose clients have included Rosa Parks and Dr. Martin Luther King, whom he represented after Dr. King became one of the leaders of the Montgomery bus boycott that culminated in the Supreme Court ruling in Gayle versus Browder, a case in which Mr. Gray filed the complaint and played a major role at every stage of the litigation. Mr. Gray also played a major role in NAACP versus Alabama, a Supreme Court case dealing with freedom of association. He argued Gamillion versus Lightfoot, the Tuskegee gerrymandering case, and he represented the African American ministers who were sued in the landmark First Amendment case, New York Times versus Sullivan. In addition to his role in 4 major Supreme Court cases in his first 10 years out of law school, go ahead kids, equal that, Mr. Gray represented the victims of the infamous Tuskegee syphilis experiment and has been involved in just about every major civil rights case in Alabama for the past 6 decades and still is. Just before we came down, Mr. Gray was telling me about a fascinating case he's working on right now involving civil rights and, of all things, electronic bingo. That shows that they are connected, shows the creativity of thinking of a truly great lawyer. Mr. Gray has received the Centennial Medal, the law school's highest honor, and holds numerous honorary degrees, including one from our own Case Western Reserve University, on which he has served as a member of the Board of Trustees. So as I mentioned, he'll be discussing his memoir, Bus Ride to Justice, with Dean Enton, and will sign copies of the book immediately after the program, which are available for purchase in the rotunda following the lecture. So without anything more, because really what more can I say, let us welcome Fred Gray.
Welcome back. It's a pleasure to have you here. It's a pleasure to see you again. I want to talk a little bit about the book and about your career. Let's start at the beginning. You originally planned to be a minister. How did you decide to become a lawyer?
Well, before I answer your question, let me first express to the Dean my appreciation for the remarks he made, and to you and to the law school and to BOSA and to the Law Review for making this trip possible. And to all of you students, I just want to say to you that over 60 years ago, I sat where you're sitting, not in this building, but in the old building on the Delta. I had no idea that I would ever be coming back to this institution under these circumstances. And I say that to you because you sit and you listen now and wonder what's going to happen to you. But I hope that my coming to this university and the story of my life will help you as you try to determine what you're going to do with your own career. It's good to see Attorney Hopper back there, and I have a friend, Charles Chandler, a young man back there who's originally from Macon County, Alabama, and who worked with us a great deal down there. He's back here now, came back to Cleveland about 2 or 3 weeks ago. He called me the other day, and I told him I was going to be here, so he's here, and I'm happy that they're here. I'm happy that each of you. Having said that, I will now, Professor, try to answer your question. And sometimes when you're trying a case and you ask a question, if you are fortunate enough to get a judge who will let you make a speech, you go ahead and make your speech because it may have an effect on the jury if it doesn't have an effect on the judge. I I was born in Montgomery, Alabama, which is the cradle of the Confederacy, in the middle of the Depression in 1930. The youngest of 5 children. My father died when I was 2. My mother had no formal education, only about 5th or 6th grade. But she told us, the 5 of us, that we could be anything we wanted to be if we did 3 things. 1, keep Christ first in our lives. 2, stay in school and get a good education. And 3, stay out of trouble. Don't get involved in the criminal justice system. I tried to do that, and I tried to instill that into my 4 children, and I hope I did that, and I hope that their children will also be so inspired. But when I was coming along in Alabama in the 40s as a teenager, there was probably only about, and you wouldn't know this, your parents would know it though. There's about 2 professions that a black African-American boy could look forward to as being professions that he was well respected for being. And you probably could help me guess. One of those would be to be a what?
Teacher.
What?
Teacher.
A teacher, that's one. And the other one would be what? A preacher. And you taught, or you was a preacher, under a in a segregated system. If you were black, you preached to black people in the black church. If you were a teacher, you taught black children in a black school. So I decided I was going to be both. When I was growing up, my mother's side used to baptize cats and dogs. A school, Church of Christ related school up in Nashville. It was a boarding school. So when I was 12 years old, I went up to that school to learn how to be a preacher. And apparently I did pretty good because the president of the school, one of our old evangelists, would go around and raise funds at churches across the country. And he decided one way of raising funds and soliciting students was to take a student along, 1 or 2 students with it, let them serve as boy preachers, preach ahead of him, or make a little statement. And then he would tell the audience, these are the type of boys that we produce. You send your son to us, we'll send him back a good man, and he'll be good and make a contribution to the school. And that's what I did. I was one of his first boy preachers, and throughout the Southeast, from Texas to Florida, all around, and I did that. I finished there in 1948. Came back to Montgomery, enrolled in Alabama State College. Actually, the name of it then was Alabama State College for Negroes, the historical black school in Montgomery. I lived on the west side of town. Alabama State was located and still is on the east side of town. I had to use the public transportation system from as little as twice a day to as much as 8 times a day. I saw many of our people who were mistreated on the buses. Sometimes when white people would come on and the bus would become full, they would take your money in the front door, you go in the back door, and sometimes the bus driver, I wouldn't say he intentionally did it, but sometimes before a person could get in the back door, he's closed it and gone. Everything at that time was completely segregated. We had a family friend whose name was E.D. Nixon. He was a Pullman car porter by profession. He had been president of the State Conference of Branches in the state of Alabama for the NAACP. He had also been the president of the Montgomery branch of the NAACP. And if a person of color had any racial problems, he would usually contact E.D. Nixon. And I had seen him try to help our people, and he was having difficulty finding lawyers. if a person of color had a cause of action against a white person, there was almost no justice to be received. First of all, there were no black lawyers, and white lawyers would be afraid to accept those kinds of cases. I made a personal secret commitment while I was a junior at Alabama State, and that is I was going to finish state. I was going to go to somebody's law school someplace. And at that time, the state of Alabama, along with all the other southern states, if a course were offered at the historical white school, Auburn, University of Alabama in Alabama, and not offered at Alabama State, Alabama A&M, or Tuskegee, historical black schools in the state, then the state would pay a portion of their tuition, room, and board. I decided I was gonna go to somebody's law school, finish law school, return to Alabama, pass the bar exam, become a lawyer, and destroy everything segregated I could find. Now, for a black boy in his upper teens to even think about that in Alabama was almost unheard of in the 40s. I finished Alabama State in May of '51, enrolled in Western Reserve University Law School in September of '51, September 21st. Finished in June of '54. Stopped by Columbus just in case and took the Ohio bar exam. A month later, took the Alabama bar exam. In the latter part of August 1954, I was advised by both of those bars that I had successfully passed the exam the first time. And on September 8th, 1954, I was now a lawyer and ready to begin destroying everything segregated I could find. I hope I answered your question. A long answer.
It's a long answer. It's a terrific answer. First of all, what led you to this law school?
Well, there were several things. I wanted to go to a good small law school, and I had received information about any number of law schools, including this one. In addition to that, I had to also go to a school where I could find some work, because we didn't have any student loans at that time. I knew I was not smart enough to get an academic scholarship to anybody's law school. And I realized that I had to support my mother was not able to do it. There were no student loans. And Cleveland in the early 50s, the illuminating company used to have a slogan saying Cleveland was the best location in the nation. If you wanted to find a job, particularly a person of color, whether it was part-time or full-time, you could usually get one in in Cleveland. Plus, there were a lot of Alabamians who had migrated from Alabama, who was living in Cleveland. Many of them had sent back and got their relatives, and they all had jobs, and I had some relatives here at the time. Then, in addition to that, then, unlike now, all of the classes were between 8:30 in the morning and 12:20 in the afternoon. So I felt,
you can blame me for that.
I felt that that would give me enough time that I could find a job and work a few hours, and at the same time be able to keep up with my schoolwork. And selection was made to attend this law school, and I'm glad I did.
You mentioned that Alabama was willing to reimburse you for some of your expenses. The Supreme Court had struck down a similar arrangement in Missouri about 12 or 14 years before you started law school. Did you ever think about challenging the Alabama policy?
I did not. I didn't want to challenge anything until I got to be a lawyer. I had enough sense to believe if I were to have attempted to raise anything about segregation or anything else before I did it, I probably would never have been successful. So a little black boy from Montgomery, had no criminal records, decided to go off to law school. They probably felt he could come back and handle some wills and some estates and represent some black folks in criminal matters and probably won't upset the apple cart. And I didn't want to give them any excuse of believing anything to the contrary.
Well, I assume that you did some of the bills and criminal cases along the way, but your first really big client, really prominent client, was Rosa Parks. But as you said, the conditions on the buses had gone back many years. Rosa Parks wasn't the first person to challenge bus segregation ordinance. You want to talk a little bit about Claudette Colvin?
Yes. Actually, the bus problem in Montgomery was a problem that all black people were familiar with, because we didn't have automobiles for the most part. Very few people had automobiles in those days. And we all used the transportation system. So either we had problems, had seen other people who had problems, or knew of persons who had problems. And I think there were people who wanted to do some things about it. There was one man who had an altercation on the bus. And as a result of that altercation, he was actually killed. So I felt, and there had been any number of people who were arrested. Under the ordinance of the city of Montgomery, bus drivers had police power. They could actually arrest you for the purpose of enforcing segregation or any other offense on the bus. But Mrs. Parks, of course, she'd been in Montgomery for a long time, and I did represent her, but there were many other persons who had been arrested under similar circumstances. Some of them we knew about, and some we didn't know about. There was a young lady, Claudette Carvin, who was a 15-year-old girl who lived in the northeast part of Montgomery and had to use, and all of the black children who lived in that area had to use the public transportation system because there was only a small pocket of black kids who lived there. And it was surrounded by white communities. They had to get the bus, go downtown, then go on the other side of town to where the black high school was. Claudette Carvin was one of those students, and on March the 2nd, 1955, 9 months before Rosa Parks did what she did, Claudette was coming from school. She sat in a seat on a bus after transferring downtown, going out to her house, in a seat that she had sat in before. The difference was, on that particular day, more white people were on the bus than usual. And while the first 10 seats, there were 2 on the side and the 2 front, were always reserved for whites, whether they came or not. The other seats, it was kind of a fluid situation. Black could sit there, but if the bus driver would ask you to move, then you'd have to stand up and let the white person take your seat. And Claudette was sitting in a seat, not in one of the ones traditionally reserved for whites, but one that she had sat in before. White persons came in, the bus driver asked her to move, she refused to do it. She told them that she had paid her money. She had a teacher, her name was Mrs. Norris, who had been teaching civics and had told them about her constitutional rights. And she did not get up. The bus driver called the police asked her to get up. She would not get up. And they literally drug Claudette off the bus because she wouldn't walk. She was arrested. Her parents called E.D. Nixon. E.D. Nixon called me, and the parents retained me for the purpose of representing Claudette. She was charged with being a delinquent, and before Judge Hill in the juvenile court of Montgomery County, she was tried. I filed motions in that court, the first motions I ever filed, challenging the constitutionality of any statute or any ordinance, saying in effect that Claudette, the state wasn't concerned about her being a delinquent. The state was concerned about improving segregation laws, and that those laws were unconstitutional under the Brown versus Board Education case, which had just been ruled on almost a year earlier, in May of 1954. The court, of course, didn't listen to my argument, or he listened to it. In any event, he declared her to be a delinquent based on unsupervised probation. I was a little disappointed on the one hand, and on the other hand, I really didn't expect the judge, under the circumstances, to release her. Joanne Robinson, who was a teacher at Alabama State and who had had a bad experience on the buses herself, as far back as 1948, was then chairman of the Women's Political Council. It was an organization of black professional women, most of whom were teachers at Alabama State, our public school teachers. And they were concerned about all the problems that our people were having, including the problems on the buses. Joanne then became very active in Claudette's case. And of course, E.D. Nixon was already involved because the parents had contacted her. And of course, Fred Gray was involved. So the three of us were very, very much interested in trying to solve the problems on the buses. We thought about the possibility of trying to have not a bus boycott, because there was an anti-boycott statute in Alabama, but we would just stay off of the buses. The results, of course, would have been the same. In any event, I wanted to go ahead and file a lawsuit in federal court, but our community wasn't quite ready. The officials in Montgomery said at the time that they were sorry about what happened to Claudette, that situation would not happen again. And of course, we did not do anything about Claudette's case at that time. But it did give moral courage to Mrs. Parks. And Claudette had attended some of Mrs. Parks' youth classes because she was also the director of the youth activities of the branch as well as secretary of the branch. And we began, Joanne and E.D. Nixon and Fred Gray, to be sure that whenever the opportunity presented itself again, that what happened to Claudette would not go unattended to in the future.
Which led to Ms. Parks not giving up her seat, as you said, 9 months later. And you represented her in her trial, and there was also going to be a protest that was supposed to be originally like 1 day.
Well, here's what has happened. Of course, Mrs. Parks lived about 3 blocks from the church that I attended in Montgomery. I was a member of the branch of the NAACP and very active because I was interested in civil rights activities. Mrs. Parks was very interested in youth, very interested in civil rights, and became very interested in my career as a lawyer. She worked in a department store in downtown Montgomery that was located a block and a half from where my office was located. So from the time I started practicing until the day of her arrest, almost every work day, and that was 5 days a week, during her lunch period, she would bring her little lunch to my office and we would sit down and we would talk. We talked about conditions on the buses. We talked about conditions of young people generally. We talked about the whole racial problems and how it could be solved. We also talked about how a person should conduct themselves in the event if ever they had an opportunity to challenge or were asked to give up their seats on the buses. So Mrs. Parks was very much familiar with our conferences, and even on the day of her arrest, we had talked that day. I was the last person that she had seen that had anything to do with civil rights. But she also knew that I was going to be out of town that afternoon. And it just happened that when she went home, the opportunity presented itself where she was sitting not in one of the 10 seats reserved, but one of the others. And she refused to get up to give her seat. And when I came from out of town, I had messages from her and from my secretary and everybody telling me that Mrs. Parks had been arrested. I returned Mrs. Parks' call, and she asked me to come over to her house, and I went over and talked with her. She told me what had taken place. This was on a Thursday afternoon, Thursday evening. And she wanted me to represent her. The trial was going to be the following Monday in the Recorder's Court of the city of Montgomery. I told her I would. And for her not to worry about it, we would be ready for her trial on Monday. I left her house and went to Mr. E.D. Nixon's house. It wasn't very far. We discussed her case because he already knew about it, because he had known about Claudia's case. He had got me involved in that one. He was the one who went and actually signed the bond for Mrs. Parks to get out of jail. And I told him then that if we're going to ever do anything about the buses, the time to do it is now. And I knew he was ready for that, and he said, well, fine. Now, Mr. Nixon was not a person who did a lot of planning. He was an action type person. So I told him that I was going to go and talk to Ms. Robinson, because she was interested in Claudette's case, and she had had an experience, a bad experience on the buses. I left E.D. Nixon's house, go across town to Mrs. Robinson's house. Got there about 9 o'clock in the evening. And from 9 o'clock on the evening of December 1st until the early hours of December 2nd, we sat in her living room and planned the details for the Montgomery bus boycott. There were several things we considered. Number one, if we're going to ever solve the bus problems in Montgomery, now is the time to do it. Two, I felt that we were going to ultimately have to file a federal lawsuit in order to do it, because the state courts in Alabama was not going to rule in our favor. I just knew that. And I also realized it takes a long time for lawsuits to begin initially in the district court and get a definitive decision in the Supreme Court. So the question is, what are we going to do in the meantime? Joanne says what we ought to do is stay off of the buses until we can return on a non-segregated basis. But, he says, that's going to take planning, that's going to take money, that's going to take a lot of work. I said, well, what else do we need to decide? I said, well, if we're going to, let's try to tell the people on the day that Mrs. Parks' trial, December the 5th, let's stay off of the bus at least for one day as a protest. And Joanne said, well, that's fine. Then I know you're all going to have a lot of meetings, but I'm going to, when we get through with our meeting here, I'm going to go and draft leaflets that's going to say another black woman has been arrested. A trial is going to be on Monday the 5th of December. Stay off of the bus in protest, and there'll be a mass meeting at Hope Street Baptist Church on December 5th. Now, she didn't know all those things could happen, and neither did I. But those were the plans. Then the question is, if we're going to do that, how are we going to get the message out? This is now Friday morning, and we're talking about Monday. We said, well, the black preachers talk to more black people on Sunday morning than everybody else. So we've got to get the cooperation of the black preachers. So I don't think that'll be a problem. We know all the preachers. I think we can get them to cooperate with us. But there's some other things we need to do too. The question is going to come up, while you're staying off of the bus, you're going to need a spokesman. So who is going to be the spokesman? And that was a real challenge, because under normal circumstances, the spokesman would have been E.D. Nixon. E.D. Nixon was not an educated man, but he was the Mr. Civil Rights, and he had a lot of people following him. But there was also another black leader in Montgomery named Rufus Lewis. Rufus Lewis was only concerned about one area of civil rights, and that is to get people registered to vote and get people elected to public office. If you had that kind of problem, he would be interested in it. If there's any other kind of problem, he was not. He had a nightclub, and the nightclub was named the Citizens Club. And in order to get in the Citizens Club, you had to be a registered voter. So we said, well, we need Mr. Nixon's supporters and we need Mr. Lewis's supporters. If either one of them is appointed as the spokesman, we may lose somebody supporters. Why don't we come up with another person who will be the spokesman and give good supporting roles to these two men? Joanne said, I tell you, Fred, who we should get. He said, my pastor, Martin Luther King Jr., has not been here long. He's pastor of Dexter Avenue Baptist Church. As you know, Dexter Avenue Baptist Church is the last church that you would expect a boycott to start, because it was elite black people who lived there. Most of them had jobs by the state or the city or the county, and their positions were vulnerable, and they weren't going to do anything that was going to interfere with them. He said, but he's a good speaker, and he will be able to move people with words. I had met Dr. King, and I told him, but I don't know like you do. If you think, that's fine. I said, well, I can tell you two key roles for the other two men. He said, what? E.D. Nixon is a Pullman car puller. This group is going to need to raise some money. He needs to be the treasurer. He knows A. Philip Randolph, the black labor leader in New York, who's president of his Pullman car puller union. That means he could get him to raise the money if E.D. Nixon is treasurer. He said, fine. But what are we going to do with Rufus Lewis and the Citizens Club? I said, well, there's another thing. Rufus Lewis is married to Jewel, who was a Clayton. And she is co-owner of the largest funeral home in town. Ross Clayton Funeral Home was the largest then in Montgomery, and is still the largest now. They have automobiles. We're going to need to get people from one place to another place. So we're going to need to have a transportation system. Let's make Mr. Lewis chairman of the Transportation Committee. He'll get his wife to get off a car. They'll get others, and we'll have a transportation system. And the only other thing left you need is a lawyer. And the young lawyer just finished case Western Reserve University then, just out of law school, would be the lawyer. We decided, one, Joanne couldn't let it be known that she was doing all this at the time, because she worked for a state institution and they wouldn't fire her. Well, she got fired anyway, but it was much later. I just have been a member of the bar for less than a year, and if it gets out that I'm stirring up litigation, they'll disbar me before I get started. So what we had to do was plant the seeds, plans that we had in other individuals' minds, and let those individuals be the ones to get the message to other individuals. And when it spread it, now Joanne said, now, I'm gonna go on and make these leaflets and get them out. When they had the official meeting, Martin Luther King Jr. was selected to be the spokesman at a meeting, and at the time they elected him, he was not present. Rufus Lewis was selected chairman of the Transportation Committee. E.D. Nixon was selected treasurer, and Fred Gray was selected as lawyer for the movement. That's what happened when the official meeting occurred. We tried Mrs. Parks' case. She was convicted. We again raised these constitutional issues. We appealed them. The official meeting took place that afternoon at Mount Zion AME Zion Church. Those officials I just told you about were selected officially in that meeting. They had the meeting at 7 o'clock. Dr. Martin Luther King was introduced to the Montgomery, the state of Alabama, the nation, and the world, and the rest of it is history.
You mentioned that you didn't want to get into trouble with the bar before you got off. Really good. So, what kind of dangers did you face? I mean, after all, there was plenty of violence and retaliation against people who called you, as you suggested. Lawyers might be particularly dangerous if they did their work.
Because when we started the bus boycott, and it's difficult when you look back over 60 years ago. It's one thing to look at it now, and it's another thing to have lived it on a day-to-day basis. What happened was we had a real problem of the buses. And what our idea was to solve the problem confronting the buses. So we had all kinds of problems. And of course, there were problems that later on developed. And while I wanted to be very careful in what I did so that I'd be sure that what I did was ethically correct, and so that the bar would have no excuse to bring any disciplinary action against me, I could not let that interfere with it. And as time passed, we had various and sundry things to develop, and it did get to be difficult. There were complaints later on filed, but I also felt that, and I said to you, once you become lawyers, try to conduct yourself in a way that no complaints are filed. But if they are, be sure you do what is ethically correct, respond to all the complaints, and get a good lawyer to help you in the meantime. And most of the time, if you're right, you'll come out all right.
You were a young man during a period when young men were subject to the draft. I think you had a little trouble with the draft board, didn't you?
Well, that's true, because as I indicated earlier, I was a minister long before I knew anything about being a lawyer. And when I became of age to register, I registered like everybody else, including indicating my religious activities. And during the whole time that I was doing the work, even with the Montgomery bus boycott, I was also serving as a minister of the Newtown Church of Christ, a church located in a ghetto area of the city of Montgomery. And still attend that church but I was expecting at some point along the way, my draft board may have decided that they wanted to change my classification from a minister's classification. But I was doing religious work, the same kind of religious work, because when I was here in school, I became the assistant minister of what was then The East 100th Street Church of Christ, which is now the University Church of Christ, is located up, Chester and 89th, right in the circle. So I was assistant minister of that church when it was on East 100th Street. I would submit to the draft board every time they required for me to make a submission of my work. I told them the religious work I was doing, I told them my other work I was doing, and they were perfectly satisfied with it. They were satisfied with it until I filed a lawsuit of Browder versus Gayle and became interested in the bus boycott. There was a news reporter who found out about my draft status, wrote stories about it. My draft board saw these stories and then immediately reclassified me from 4D, which was a minister's classification, to 1A. And I would not have mind going in service if they had not been using it for the purpose of stopping my activities with the Montgomery bus boycott. So I appealed the decision all the way to General Hershey, who was then Director of Selective Service, and I was supposed to report for service on the next day, and I received a telegram from the state director telling me that the National Director of Selective Service had ordered him to postpone my induction indefinitely. And so I was not drafted.
Maybe one of the few positive things that those of us who are old enough to remember General Hershey quick technical question. Browder against Gayle was the case in which the Supreme Court invalidated the bus segregation rules. Why was the case filed in the name of Browder rather than in Ms. Parks' name?
Okay, of course. I recognize when, even before we had filed the lawsuit, that if we were going to ever solve the problems on the buses, it was going to take an action in federal court. Because the state of Alabama would not ever let you get a federal constitutional issue decided. They would find some way of avoiding that. So I wanted to be sure that when we filed a case in federal court, we would have plaintiffs involved in it where there would have been no excuse for the court not ruling on the constitutionality of the city ordinance and the state statute that required segregation on the buses. The city of Montgomery had pending the case against Mrs. Parks. Technically, it was not a criminal case because they consider under Alabama law your city offenses as being offenses against the city, and they're quasi-criminal as distinguished from real criminal. However, her case was up on appeal. If I had included Mrs. Parks as a plaintiff in that case, someone would have said that was a collateral attack on the appeal that's going through the state court system. So I said to myself, without saying anything to anybody else, just let Mrs. Parks' case proceed to go on up the state court system the way it's going. And I wanted to file a case for Claudette Carvin a long time earlier anyway. There was another young lady, Mary Louise Smith, who had been arrested in October of '55 that we found out about after Claudette's case, but we didn't know about it until after we started the bus boycott. Her father had simply paid a $5 fine and kind of forgot about it. And then there were other individuals in the community who had had problems on the buses. So I selected, when we decided we was going to file the suit, that we would end up looking at all the persons who said they would be willing to be plaintiffs. I would then select those persons who were involved, and I wanted to be sure that Claudette Carvin would be one of those who would serve, while I didn't want to name her as the lead plaintiff because she was a minor and I'd rather have an adult not having to sue through a parent And so we ended up filing Browder versus Gayle with those separate plaintiffs, and as Mrs. Parks' case proceeded in the state court.
And eventually that you won the case in the district court, the federal case, and then the Supreme Court affirmed, and shortly after that, the city acquiesced in the desegregation.
Yes, but let me just mention this, and I say this particularly to your students. I had enough sense to realize that I was just out of law school and I needed a lot of help. I knew the state of Alabama would have the best legal minds, best that money could buy, to oppose what we were doing. So I had enough sense to know I needed some help. There was a black lawyer in Birmingham named Arthur Shores, who was very good and who had been handling civil rights cases. But I'd also heard about Thurgood Marshall, and I had been working with the local branch of the NAACP, and at that time he was general counsel. I got on the phone. Never talked to Mr. Marshall before. Was able to get him at his office. He had heard about what we were doing in Montgomery. Told him that I needed his help and his assistant's help. Told him what was going on and asked him, can I come to New York and talk to you and your assistants and you help us with these cases? And he says, fine. As soon as we made arrangements, I went to New York, met Mr. Marshall. He particularly assigned the responsibility to Robert Carter, who later became a United States federal district judge in Manhattan. And from that day, the third week in December of 1955 until this day, I have had excellent working relationship with the NAACP, the Legal Defense Fund. As a matter of fact, the first book signing I had was on, I think, the 23rd of May. Cheryl Othel, who is now the Director Counsel for the Legal Defense Fund in New York, had that event in New York for us. So I realized that I needed some help, and I was able to get that kind of help. And I remember Mr. Sonfield, who was on the faculty here, was my legal advisor when I was in school. He came to me once and tried to convince me to stay here and practice law in Cleveland. He thought that, and he was going to get me introduced to some of the black lawyers in town, and thought I could develop into a good lawyer, but thought they wouldn't give me the opportunity in Alabama. And I thanked him for his offer. I didn't tell him what my plans were, because I didn't tell anybody that, but I did say the only reason I came to Cleveland was to go back to Alabama to practice. He said, well, if you must go back, let me give you some good advice. Don't be afraid to share a fee with a lawyer who has more experience than you. I did that. For all of these cases, including Browder versus Gayle, I ended up getting Arthur Shores, the great civil rights lawyer from Birmingham, to work me on those cases, and he did it on all these other cases too.
Well, we've been going for quite a while, and we're clearly not going to get through everything that you've done in this time. Let me, first of all, that's one reason why we'll break shortly, so that maybe people can buy the book and get the rest of the story. But let me just ask you a little bit about the Tuskegee syphilis case, because that one really didn't result in a trial, but it was a really major problem and a really major contribution on your part.
The Tuskegee syphilis study involved about 623 men who basically were farmers in rural Macon County, Alabama. I found out that it started in 1932, and it was supposed to be well, the title of it was the untreated syphilis in the Negro male. But the federal government had a program. They found that there was a great deal of syphilis in any number of states. As a matter of fact, there was the Rosenroll Foundation had been treating syphilis some years later in Alabama, Tennessee, and some other states. They stopped that program, and there were some doctors who knew that in Macon County, Alabama, there were quite a pocket of syphilis. So they were able to convince the Surgeon General to let them engage in a study. It's supposed to have been a short-term study of untreated syphilis in the Negro male. They had the white health officer of the county and a Negro registered nurse who sent out notices to the churches and schools and asked men to come, that there was a new health program. They told them that this health program, they would end up examining them, and many of them had never been examined by doctors. And whatever they found wrong with them, they would treat them for it. They did not tell them that it was a study of syphilis and that some of them may have syphilis and that they were not gonna treat them even though they found it. So the study existed for some 40 years before it became generally known. It was known, however, in medical circles for persons who were interested in studying syphilis. But in July of 1972, and some years before that, an employee for the Public Health Service ran across these reports, and he complained to his superior about the study. They had him to come to Atlanta to the Disease Control Center and talk to officials over there. And they wouldn't do anything about it. They told him that this was a federally funded program and he was not involved in it. But he finally told a newspaper reporter in San Francisco, whose boss got in touch with a reporter in Washington, D.C., and a story came out, the first one, the latter part of July of 1972. One of those persons was a man named Charlie Pollard, who was a farmer in a community known as Sullivan, a little north of Tuskegee. Came to my office a few days afterwards, said he was one of those men, had a copy of the local newspaper, and said he thought the federal government had mistreated him and wanted to know if I could help him. I told him I thought I could. Had him to bring the other persons who had been in the study with him that he knew about, got all the information we needed. Ultimately, we were able to file a lawsuit that resulted in settling that case. And later I was able, along with others, to get President Clinton to render an apology to those men. And we went to the White House and announced, as a matter of fact, Herman Shaw, who introduced the president at the time of the apology, also told the president that the men were interested in having a permanent memorial in Tuskegee that would acknowledge the contributions that they had made to health care, even though they didn't realize it. And he announced the formation of the Tuskegee Human and Civil Rights Multicultural Center. All of those men are now dead, but before they died, they told me they wanted to search a history museum. And I told them if life lasts, we would do it. We do have such a museum. Jonathan has had the opportunity of seeing it and have some information about it. It's a nice museum that gives you really the history of civil rights as it evolved from around Tuskegee. It tells about the Tuskegee syphilis study, and it tells about many other precedent-setting cases, and we invite you to come and become a part of it and share it with us.
One last question, Fred. In recent years, a group of scholars have been writing about civil rights and the movement, and they have suggested that litigation in courts played a relatively marginal role in bringing about desegregation and social reform. That it was really more a function of social mobilization and political activism, things like that. How would you respond to that?
I would say that is inaccurate and is contrary to history. I can tell you from firsthand information about Alabama. The state of Alabama has not done anything at all to do away with discrimination against African Americans. Even after slavery, after Reconstruction, where we had African Americans in Congress, they adopted the Constitution of 1901, which was designed primarily to disfranchise African Americans and poor whites, and they did a very good job of it. And still has not changed that Constitution, and the Constitution has been amended more times than any other Constitution in the country. But you can take cases that I have handled in Alabama, has involved the buses, has involved lunch counters, has involved destroying segregation in all of the institutions of higher learning in Alabama, Auburn, University of Alabama. It has also filed suits that have desegregated 105 of the 119 school systems in the state, and everything under the control of the State Board of Education. So everything that is now desegregated in Alabama, the state of Alabama has effectively filed and responded and fought every case along the way. They have never agreed to any of the issues. We've had to take these cases, even when they barred the NAACP from doing business in Alabama on July, I think it was June 1st, 1956. It took us 8 years to get it so that the NAACP could do business again in the state of Alabama. So it is the court orders that have been able to change the landscape of this country. And in order to get a court order, there's several things you have to have. One, you have to have a lawyer to file a lawsuit. And in Alabama for a long time, until recent years, we didn't have any reciprocity. So they limited by keeping lawyers out, and if lawyers don't file the lawsuit, you don't have a problem. Secondly, it took individual plaintiffs. And these persons, when they end up filing the lawsuits, they would lose their jobs and lose almost everything else they have, because pressure would be brought on them, if not by their employer, by somebody who has the pressure. So you had to have plaintiffs, and then you had to have federal judges who were willing to make the right decisions, like Frank Johnson. So it is the lawsuits that's going on. And I was talking to the dean earlier, and I might just challenge all of you lawyers out here and tell you we have a very interesting case going on now in Alabama. One involving the right to vote, one involving civil rights, one involving economic ventures, electronic bingo. The case is pending in federal court. We have a constitutional amendment that was passed by black folks in Macon County to have electronic bingo. It existed for 4 years. The governor decided to close it down. It closed it down, took the very machines that were in the black county to the Indians. They're using those machines now. They closed the facility down in Macon County that was generating 2,000 jobs and millions of dollars for the various ones. And there's pending now before the federal court a case involving it. And it's one that deals with voting rights, it deals with civil rights, it deals with economic rights. And if you law students want to, I'm going to send you a copy of the pleadings in that case, and anybody who want to work on it, I think you will find the first part of a brief that I wrote, and I took time to write this part of it myself. and they sent a motion for leave to amend our complaint, where we were amending the complaint to add, after the Supreme Court struck down the section of the Voting Rights Act, because that was one of the provisions in it, so we amended it. But I ended up telling the judge in that case that what Alabama is doing in this case now is the same thing it has done in all these other cases. Then I outlined them, and it was really a litany of cases that I have handled. All of them, the object, purpose, and the results was to deny African Americans their constitutional rights. The facts are different. This is electronic bingo. The Vermillion versus Lightfoot case was where when we got a chance to vote, they changed the city limits and put us out. In the county just below us, in Bullock County, when we got the right to vote, they extended the term of office of the white county commissioners so that the term didn't even expire. We had to get that declared unconstitutional. Then in another county, George Wallace's home county, when we got the right to vote, they used to have single-member districts for the Democratic Executive Committee at the time when the Democratic Party was controlling things in Alabama. And they changed it from single-member district to a district at large. So the issues in the facts are different, but the issues are the same. And I'm going to send to you all the pleadings in that case and see if you really want to work on the civil rights case. If you do, you can help us.
Okay, well, we could sit here for at least the rest of the afternoon. But I think we really need to call the formal part of the program to a halt. Fred, it is an extraordinary honor to have you back. It is really inspiring to know that although you're coming up on your 60th year out of law school, or your 60th anniversary out of law school, that you're still going strong. Thank you so much for being with us. Let's call the formal proceedings to a halt, and thank Fred for being here. We'll adjourn shortly out to the lower rotunda, and anybody who's interested in book, it will be available there.